So, hello everyone, welcome to Logos. Today we will be dealing with legal maxims, and legal maxims are very important in a student's life or in a legal profession or in a judiciary, anything. Because when you're a student, you need to answer with an example, or when you're coding something, you need to mention the legal maxims for scoring, and it helps very much. So, some of the maxims get attracted, and maxims, when you mention that meanings with the examples, it has more weightages. When you go for your legal professions, these maxims serve as like when you're reading some judgments, or when you're reading some documents, it will have some legal maxims which you can easily relate to it, and you can just understand the meanings of what is mentioned. Some of the things will be mentioned in maxims which has to be mentioned like that. So it is mandatory that you need to know about the maxims. And when you go for judiciary and all, when judges write their judgments, they will quote some maxims. And so, in a legal profession, in whether a student or you're an advocate, you're a lawyer, whatever it is, you need to know some maxims which are very much important. And the rest, like every maxims, you will not be like you cannot have an hands on it, but some of the maxims you need to know. And we'll just see some maxims in this video. I'll be dealing with maxims in an alphabetical order. Here today we'll have alphabet A, and this alphabet A will have two parts. This is the part 1. So now we start. Let's get started. So alphabet A, the first maxim which we are seeing is ab initio. What's ab initio? It's a Latin word and which means from the beginning or from inception. From the beginning or from inception. So what can you say? From the beginning itself, you'll say, no, from the beginning itself, it was like that. From the beginning itself, it is used to be like that. Which here we can mention is that Dilip Kumar Mukherjee versus Commissioner, Tax Officer, and others. Is the case in ab initio. And example, if we can quote is child marriage. Child marriage is like void ab initio. You have ab initio and void ab initio. Void ab initio is that is void from the beginning. So child marriages are void from the beginning itself. It's not considered as marriage. It is not a marriage in the eyes of law. So it's void ab initio. From the beginning itself, it's void. Okay. So this is a simple meaning of ab initio. The next is actionable per se. Actionable per se means the very act is punishable and no proof of damage is required. The simple act, what you're doing is punishable, and you don't have to have any clarification that it is punishable or not. That is the actionable per se. Okay, so the best example is defamation cases. So any intentional false communication, either written or spoken, that harms a person's reputation, decreases the respect, regard, etc., can cause defamation. Okay, so defamation can be, yeah, defamation can be in form of tort as well as crime. So in tort, if you have defamation cases, damages is the option. Monetary compensation can be given. And in crime, if it happens, if the case is under crime, criminal procedure, or will be the punishment will be the sought. The next is actus reus. Actus reus, mens rea, and you will see in criminal cases. That what is the actus reus? Actus reus simply means guilty act. The act is guilty. And case you can see is one case is that additional commission of income tax, and another versus Darga Pandarinath. An example is murder. Murder is a very simple example for this actus reus. When someone willingly takes the life of another person, they are committing actus reus. Okay. Actus reus refers to criminal action involved in a crime. It is a guilty act that a person does when they commit a crime. So the act is guilty. That is actus reus. Okay. Now the next maxim, actus non facit reum nisi mens sit tria. This is a simple maxim, don't worry. You can divide the maxim into two or three. Actus non facit. Let it be in one position. Reum. In the middle, nisi mens sit tria. Divide that into three parts. Okay. Actus non facit, not reum, nisi mens sit tria. Okay, you write down and you'll be have you can just have it in your mind very fast. Okay, an act does not make one guilty unless it is accompanied by a guilty mind. What does actus non facit reum nisi mensit tria means is that an act does not make one guilty unless it is accompanied by a guilty mind. So there has to be a guilty mind associated with an act. This is what this maxim says. A case law is State of Rajasthan versus Sherara. Okay, for committing a crime, the intention and act both are taken to be crime to be associated. So you can refer to the case law here. The two components which is this maxim associated are a physical element is associated and a mental element is also associated. Okay, an example is that when someone accidentally bumps into another person on the street without any intent to harm, in this case the physical act of bumping into someone's is actus reus and occurred, but there was no guilty mind or intention behind it. So there's no mens rea associated with it. Okay, you're walking and you're getting hit by someone, and both of you didn't have any kind of intention that to hit the other person. So there is no actus rea, there is no mens rea. So this is the simple example for this. Okay. Now moving on, ad hoc. What is ad hoc? You might have heard of ad hoc and in your day-to-day happenings and all. So what does that mean? It means for the particular end or case at hand, for a particular purpose. Okay, ad hoc, simply simple meaning. Okay, the case law will be addition company limited madras versus collector of central excise. So what is ad hoc? This is made or done suddenly for a particular purpose. You might have heard of ad hoc committee. Form an ad hoc committee for some purpose. Okay, an interim committee formed to take care of a specific matter in an organization. It is dissolved once the purpose has been accomplished. Okay, once this ad hoc committee gets dispersed, after this is the purpose is achieved. So an example is that a committee made for an annual day function at school. So some teachers will be made one committee, made into a committee, and they will be assigned some roles, some particular things and all. So once the annual day function is over, this committee is dispersed. Or you can, in your corporate life, you can see for a project management team is made, and once you have achieved that goal, and once the target is achieved or whatever, what is the committee made for what purpose the committee ad hoc committee has been made, once the purpose is achieved, it automatically dissolved. Okay, that is ad hoc. For a particular purpose only that committee is formed, or for a particular purpose ad hoc. Okay, for the particular end or case at hand. Now next, alibi. You might have heard this every now and then, and you might be very familiar to this maxim. Alibi, alibi is like whatever pronunciation would you see. Meaning is that at another place or elsewhere. Okay, I was in some other place. I was not here. I was elsewhere, and you have like you for this is mainly for the prosecution cases when the accused has to prove that like he was not in the place He was elsewhere when that thing happened or the crime happened. For proving that, this is mostly alibi is used. And they have to have some eyewitness or some evidences also. This alibi is not believed just like that. You have to have strong evidence to prove your alibi. Okay. So here I've mentioned some case laws. It can be very helpful for examinations and all. Munshi Prasad versus State of Bihar. Here, the case is accused presence at a reasonable distance from the place of occurrence is necessary to prove a defense of plea of alibi, and the distance should be at least 100 meters. Okay, a simple case. And Lakhan Singh versus State of Delhi, NCT Delhi. Here, court emphasized that defense of plea of alibi should be raised at the earliest opportunity and not when the stage of defense. Okay, the accused failed to prove any reasons of explanation for not raising defense earlier. If you are not raising your defense that earlier, only when it is on your evidence part, evidence stage, you cannot bring the alibi. You have to when you're clear that you're not in that case, you have to prove your defense. Do it earlier. Okay. Now, an example for this alibi you can see as the Drishyam movie. Drishyam movie is one of the simple example when this Mohanlal, you can say Mohanlal proved that he was not in the place, not at nor his family, or he was in the house when the crime occurred or the person died. He was elsewhere. He was doing some retreat purpose. He was in movies and all. So this is, and he has to substantiate with suitable evidences also. He has to prove that he brought on cinema tickets, film tickets. For that, he brought in the hotel bills, etc. So this is the alibi which you have to have evidences also. Okay. So otherwise the alibi will not be valid. So for now, if a man acts as accused of selling drugs to a minor school in a school premises, he can present evidence that he was at his workplace at the time of sale. So somebody else might have sold the drugs to the boy, and somebody identified this person as X, but he was at his office. It might be a resemblance of him, might be somebody else. And if you can put in your evidences that you were not the person, you were somewhere else, that you can produce your the biometrics things, or you can produce your colleagues this colleagues if they are giving a witness that this person was with me when what your time what you're referring is this time he was in the office, this then you can prove your alibi. Okay, you are not the person in what you're mentioning. So this is a simple example. Now, amicus curiae, this also is a very common um, maxim which you can see in your day-to-day life. Okay, meaning a friend of court or member of a bar who is appointed to assist the court. Very easy. Amicus curiae is appointed for this case. You might have every now and then you will be hearing this now in your legal life. So he is an important advisor of the court of law in a particular case. Okay, one who assists the court by furnishing information or advice regarding question of law or fact. What the court wants from that person, and he has to act upon it. He has to produce the things as per the court, what the court demands. This is he is a friend of court. Okay, so a case law can be Manoj Nara versus Union of India. A point of great public importance was brought up before the court, and the court appointed amicus curiae to assist the court. Broadly, the point was legality of a person with criminal background of having committed criminal offences appointed as the missionaries of central and state governments. This is one of the case, and the next case is Public Union of Civil Liberties versus State of Tamil Nadu. Here, Adjudicable is appointed as amicus curiae, the case related to gravity of problems of bonded labor and steps to be taken to implement the Bonded Labor System Abolition Act 1976. So, he is a friend of court. He will act upon upon the direction of court, and he will produce all the evidences, whatever things the court requires, and to prove the case or whatever to find out the solution for the case. Okay. Now moving on. Now we'll see the next. This is the part one, and we'll see the next part two in our next video. Okay, thank you.